So talking about, who is affected, obviously folks who have a disability of some nature that would affect their ability to access websites, this is a benefit to them. Businesses that own or operate websites, especially if you're engaged in some type of commerce, whether or not you're operating exclusively on the web or your website is an extension of your physical business, my view, and I think Skip joins me in this, is that ultimately the courts are going to require anybody with that type of website where you engage in the sale or providing of services or goods, or if you're a government website, that you're going to have to come into compliance. And why now? This really started several years ago when the DOJ, the Department of Justice, talked about taking action with respect to websites. After several years and various machinations of the DOJ potentially issuing a rule, they ultimately withdrew their notice of proposed rulemaking in late 2017, and that started all the way back to 2010. We talked about this last month a little more, but with the DOJ pulling out of taking any responsibility for making an actual rule on website compliance, it's now up to the courts. And here in Florida, we had a case in 2017 involving a plaintiff who sued Winn-Dixie and prevailed, and that really has sparked a fire and what we think could be a firestorm of litigation around the country. And the issues, some of these are identified by the DOJ, and really they're still growing. Obviously, folks who have vision impairments are affected because they use screen reader technology that needs to be compatible with websites. Deaf and hard of hearing folks need captions for videos and other types of visual material on the internet. If you can't work a mouse, you need to be able to access the website through keyboard access. If you read slowly, or if you have difficulty filling out forms on the internet, sometimes if you've ever gotten up, you filled out something and walked away and it times out on you, how frustrating that can be. Imagine if you just can't get through the form fields fast enough. There's other issues. Flashing lights could create issues for people subject to seizures. Privacy policies. In California, for instance, several businesses that collect personal information are required to have a privacy policy, and that's a growing trend. Nevada is moving that direction. Nothing that I'm aware of yet in Florida, but we have Florida businesses who do business in those other states, including California. And if you're required to have a privacy policy and your privacy policy is not accessible, potentially you could be in violation of that law as well. And there could be other issues that we just haven't identified yet. Anything else you could think of?
Well, before we go to recent legal developments, I wanted to remind our listeners about another aspect of why now, which is because the number of lawsuits have been growing exponentially for the ADA, but in particular for websites. Just to give you a little bit of perspective on that, the ADA lawsuits in federal courts in 2013 were about 3,000. By 2017, there were 8,000. And then for website accessibility issues, in 2017, there were 814 lawsuits filed just on that issue, and 335 of those lawsuits were filed in Florida. And that's why we think it's an appropriate time to bring this to your attention, because it doesn't seem like it's going to stop anytime soon as it works its way through the different courts.
That's right. It's a great point, and that's why we think pretty much anybody that owns or operates a website, at some point, if you have not already been targeted, there's a good likelihood that you will be. So this is the case that really the first one that went to trial, where we had a judgment against a business, and it was this Winn-Dixie case here in Florida in 2017. And you want to do the overview of that one? Okay. So here's what happened in this case is you had a blind individual that sued Winn-Dixie because, as he alleged, he shopped at Winn-Dixie. He wanted to get services and items that were available online, and he wasn't able to do so. And so he specifically alleged that he wanted to get coupons that were only available online. He wanted to fill prescriptions through the online process that was available at the Winn-Dixie website. And third, he also said that when he traveled, if he ever was away from home, he used Winn-Dixie's map feature on their website to access the nearest location, the nearest Winn-Dixie location. And he did that through the website, or he wanted to do it through the website, and he wasn't able to. And why are those issues important? We'll touch on this a little bit more and talk about some other cases, but we're in the 11th Federal Circuit here in Florida, and the 11th Circuit precedent has been interpreted to say that the ADA only applies to businesses to the extent that that a website is a physical, that a website is an extension of a physical location, that it only applies to physical locations. And that's an area of debate that we'll dig into more a little bit later. But here, what Gomez certainly and his lawyer were certainly addressing or getting by as an initial hurdle was this issue of only of getting services on the website that weren't available to disabled folks that were available to everybody else, and he had to actually go into the store to get these services. And so obviously, if he could only get coupons online, and then if the coupons were only available online and he couldn't get them, that's an issue. But what's I think interesting about this one is the map feature, because that map feature is something that every business pretty much has now. A lot of people take a map and you can type in your address and get directions to a business, and a lot of website, even small operators, will have a feature that allows people to go on the website and find their nearest route or their nearest location, or how to get to their location. And that, I think, is what should open everybody's eyes to the fact that this could affect several people, several types of different businesses. So ultimately, this case in Gomez, the Winn-Dixie had made some modifications over a course of a couple of years to their website. In fact, they spent about $9 million on improvements, had identified the fact that there were no, or that they had accessibility issues, but they said at trial, well, they didn't know what the standard was. They didn't know, what they were supposed to do. So they identified issues. They set money aside, $250,000, and just hadn't implemented any changes. And the plaintiff's attorney put an expert on who said that the website could be made accessible to folks with sight impairments and technology to overcome that for a cost of about $37,000. And ultimately, the court in this Winn-Dixie case said, look, it doesn't matter whether it was $37,000 or $250,000. You had a duty to make the website accessible, and you failed. And the court entered an order of injunction making Winn-Dixie bring their website into compliance. And what's important to note here is, Winn-Dixie was correct in a sense that there's no actual legal standard that says exactly what you're supposed to do, but you are supposed to, in that case, you use reasonable measures so that you can provide reasonable accommodations for individuals with disability. And I guess by presenting this $250,000 figure with regard to what they thought was going to be the estimated remediation costs, and this is just reading between the lines, it wasn't clear from the case, but I read that to be Winn-Dixie's argument that, well, it's not reasonable to hit us with an adverse judgment here because the costs were so high to actually make the modifications. And I think the court just didn't buy that argument. I think the court clearly said in the opinion, whether it's $37,000 or $250,000, you have to make those changes. And we've got several other cases I know we want to talk about, but what else would you add on that one, Skip?
Well, it's the kind of the watershed case that opens up the doors for other people doing these type of actions. And I think it's important for our listeners to keep in mind the context of these ADA cases, because there's a membership of the bar on the plaintiff's side that brings these cases, and some of the federal courts on the traditional ADA cases have been pushing back, thinking that there are professional plaintiffs that are not interested in really helping the disabled as much as the attorneys are interested in collecting attorneys' fees, and so there's been some pushback on your traditional cases. With the dawn of the internet and it becoming so important in everyday commerce and everyday life, I think the plaintiff bar are looking for new ways to have recoveries in cases, because under the ADA, remember, there's no actual damages that you recover. The remedy for an ADA claim is essentially an injunction that requires the defendant to make sure that they're in compliance with the ADA.
And yeah, there's going to be pushback on both sides of this issue, and we're seeing a lot of litigation, and it's interesting to see how the courts are dealing with it. One other point I wanted to make on this Winn-Dixie case, we'll see this as sort of a recurring theme, but one thing the judge says here is, and it's something that we've been recommending, is the court talks about other websites that are accessible to this particular plaintiff, to Mr. Actually, I have Gomez v. Winn-Dixie, but the plaintiff's name was Gill in that case. I think it should be Gill v. Winn-Dixie. So I apologize for that. But what the court says is, well, Publix was accessible to the screen reader technology, Walgreens was accessible, and even sites that were not fully accessible, they had posted some information on their website, and I want to grab the language right out of the case, because I think it gives us one of the answers of, well, what do you do now? And what the court said was that in some circumstances, if the screen reader technology does not work, a website might put an accessibility notice on a website by the creator to showcase that the website is working diligently to create a better experience for the low vision or blind users. And then the court notes that no accessibility notice was found on Winn-Dixie's website, and nothing on the Winn-Dixie website announced any proposed changes to be made in 2017. So if you combine that with the fact that Winn-Dixie had testified about the upgrades they made and that they put money aside for the updates, you just have to wonder, as a lawyer especially, whether or not Winn-Dixie's case may have been helped had they at least put that notice on there. And we're going to talk about that a little bit more and some other steps that we think you can do, in addition to putting a notice on your website and trying to make changes. What else can businesses do? So let's talk about some of the issues that have come up in these various cases. So this first one is really interesting because the courts are split all over. But the issue is whether a standalone website is subject to the ADA, or whether you have to have some type of nexus or connection to a physical location. And a great example of this is Netflix. Netflix doesn't have standalone stores. They just offer their services virtually via the internet. And another one that I'm not familiar with the services directly, but I've heard about Blue Apron. Blue Apron is one of these companies that delivers food to you, and I believe you just go through the internet, and they don't have storefronts. They just deliver the food to wherever you are, and it's like pre-made meals, from what I understand. But Skip, do you want to cover a little bit? Go through these cases.
I thought I'd start with a broad view of what we mean when we say there's a split amongst the courts. And what we're talking about are the circuit courts of appeal, which are the appellate courts at the federal level, and they're the appellate courts just below the Supreme Court of the United States. In the United States, there's 12 circuit courts of appeal, and they have jurisdiction over various states. As Eric said earlier, we're in the 11th. And the split is the majority finds a narrow view of this, and they'll say that the ADA doesn't apply to websites because there's not a sufficient connection between the discrimination the plaintiffs allege for the website and the actual physical place. And then there's a broader view. The majority of the circuits have that narrow view that I just described. The broader view is that the ADA applies even in the absence of some connection to a physical place. My view is that that's actually the better reasoned opinions, that it should apply to any type of service that's being provided, whether there's a physical location or not. And some of the language that has been used by the circuits that have looked at that have conclusions like this. it would be absurd to conclude people who enter an office to purchase a service are protected by the ADA, but people who purchase the same service over the telephone or by mail are not. And another very well-respected judge wrote, the defendant asks us to interpret public accommodation literally as denoting a physical site, such as a store or hotel, but we have already rejected that interpretation. An insurance company can no more refuse to sell a policy to a disabled person over the internet than a furniture store can refuse to sell furniture to a disabled person who enters the store. Now, we're in the 11th, and the important thing for you to know is that the majority of the district courts within the 11th Circuit that have considered the question of whether websites are public accommodations have uniformly held that the ADA does not apply to a website that is wholly unconnected to a physical location. So that brings us to the Gomez case up there. This was a case where the plaintiff was legally blind, and the defendant was the owner and operator of a chain of high-end audio and visual equipment stores. And after going through what other courts had done and what the 11th Circuit had done, not on a website type case, but another ADA case, they considered that based upon the statute, that a website that is wholly unconnected to a physical location is not a place of accommodation under the ADA. And they dismissed the case. But what was really important to me in this was what the plaintiff alleged, because he alleged that it was clear he was planning on using the website, but never intended to utilize the physical retail location. He planned instead to only order the audio equipment online and have it delivered to his home. So the court concluded that the ADA did not require places of public accommodation to create full-service websites for disabled persons. In fact, they said the ADA does not require a public place of accommodation of a website at all. All the ADA requires is that if a retailer chooses to have a website, the website cannot impede a disabled person's full use and enjoyment of the brick and mortar store. So that was what was decided in 2017. There's a more recent case that just came out within the last 30 days, also from the Southern District of Florida, and that's called Haynes versus Polo Operations. Again, the plaintiff was a blind individual, but he was also a teaser. Remember when I talked about your, tester. Remember when I talked earlier about your traditional ADA cases and professional plaintiffs? This is a plaintiff who tests different businesses and enterprises to ensure that they have public accommodations that comply with the ADA. They go around looking for violations of the ADA. The defendant in this case was the chain of restaurants that have restaurants throughout the United States. Plaintiff tried to utilize the website, was unable to do so because it didn't have readable screen software, and sued. The defendant again tried to dismiss the case and was successful. And in part, it was because of what was alleged. That plaintiff again did not allege the attempted to visit one of the physical restaurant locations, or that he intended to visit one in the future, and that he failed to allege that the website impeded his ability to access the physical restaurant locations or the goods and services offered. So that's the most recent case in Florida on that issue.
And what I think that is, not only do we have decisions from different jurisdictions, like if you look here, here's Netflix. They get sued in 2015 and 2012. So these are actually going back a few years. In one case in Massachusetts, they file a motion to dismiss and it's denied, and because of the lack of a physical nexus. And then in the Ninth Circuit, which is the West Coast out around California, there's another lawsuit, and in that case, they're successful with a motion to dismiss based on the same reason, because the website's not connected to a physical space. But the interesting, what particularly jumps out about websites is, unlike a storefront location, if you operate a store in Orlando, Florida, if you're getting sued, you're going to get sued by somebody in the area of Orlando, Florida, who's trying to use your store. with the web, most people operating on the web are operating a national or international business, and so you can get sued, I think, quite easily. I mean, if you're providing services or selling goods around the country, then anywhere where you have potential consumers that are trying to access your services, which could be California or New York or Massachusetts or somewhere else, you could be subject to a lawsuit there. And this is the ultimate in this concept of forum shopping, and that's basically in the legal world for our non-lawyers that are listening. This refers to the concept of going and trying to find the best place to file your lawsuit where it's going to be most advantageous for you as a plaintiff or representing a class of plaintiffs. And that's what I see happening here. Is if Florida continues to shoot down, if cases against Netflix and online pizza ordering services or other businesses that don't have a physical location fail in Florida, and you're operating one of those businesses here out of Florida or Georgia, somewhere in the 11th Federal Circuit, then I would expect that you'll probably get sued somewhere else. And I just want to add another note on that. There are other areas such as New York and California that do offer, under state laws that mirror the ADA requirements, do offer money damages. So even some more incentive for potential plaintiffs. And I think we both agree that, that if, to the extent that even those courts that have said you need a physical nexus, I think ultimately our advice is going to be, regardless whether you have physical nexus, you need to come into compliance.
I think that's right. And Eric, don't you think that because there's the split, and even though a majority has the narrow view at the Circuit Court of Appeal, eventually it's going to end up in the Supreme Court of the United States for determination.
If somebody pushes it and pushes for the circuit split, then you could end up there, or you just have people that just decide they're going to file their suit somewhere else. But I could see that getting challenged, and the Supreme Court taking that up. And I don't think I tend to agree with Skip. I definitely agree with Skip on this point that I don't think it's even that tough of a call. I think it's a little ridiculous to think that you can have a physical business and you have to comply with the ADA, but because you're offering your goods and services, you're taking advantage of the fact that you can offer those virtually, that you don't have to comply with any of the with the ADA's requirements, and I just don't see that standing up in the long term. So another argument that's been raised, and I think this is especially now with the DOJ in 2017 deciding they're not going to issue a formal rule on the ADA, but it's an argument that came up in some cases back in 2017 and some even before that, was this concept of due process or primary jurisdiction. And that's where businesses that are sued said, well, due process is, we don't know what the requirements are. There's no rule that specifically addresses this. But the DOJ in 2010 had announced that they were going to make a rule, and so until that rule comes out, we don't. You can't sue us for doing something when we don't even know what the requirements are, and that's a mix. The primary jurisdiction argument is this is the DOJ's jurisdiction, so the courts should essentially not rule on this until the DOJ has spoken. Well, the DOJ has by, and again, this goes back a lot to our last webinar. The DOJ had in 2010 announced it was going to make a rule, and by 2017 withdrew that announcement and essentially bailed out of the issue. So I don't see that argument carrying any steam anymore. But it did. It worked in one case. Ironically enough, here you've got in California, you've got one case where it actually worked, and then two other Central District California cases in 2017 where it did not work. And similar to that Gill case with Winn-Dixie, where the court mentions that banner and giving notice regarding the accessibility, here you have the court granting a motion to dismiss in California based on this due process and primary jurisdiction argument. But the court also noted that the defendant provided this accessibility banner, directing users to a phone number to order the same products and services, here Domino's Pizza. And then when CVS was sued, they made that same primary jurisdiction argument, and they lost, but the court distinguished that Domino's case by saying, well, Domino's had phone access. And apparently it must have been, you could read between the lines there that CVS did not.
Can Can I
Yes,
just
absolutely.
let our viewers know what it said? Because it might be something that you consider doing now at a minimum to help protect yourself. That when you went out to the website, there would be this statement. If you are using a screen reader and are having problems using this website, please call a 1-800 number for assistance. And in the opinion, the court noted that this phone number was staffed by a live representative who can provide blind or visually impaired individuals with assistance using defendants' websites, although the callers may experience delays and be placed on hold. And that was the only place I recall seeing that mentioned in the decision, but I do think it made a difference. And I think it made a difference because it showed that they weren't sure exactly what to do, but they were being proactive and helping the disabled people have better access.
And it shows, it's a little behind the scenes of the realities of litigation, especially where sometimes a court may want to rule in your favor, but you got to give them something to hang their hat on. And there it could have been, that the court liked what they did with the banner, but wasn't sure that they could, use that as a complete legal basis, and so the court accepted the primary jurisdiction argument. But in consideration of the fact that Domino's had done some other stuff well.
And I also think as a practical matter, this is an example of the court trying to let the Department of Justice and the Attorney General know that Congress had vested in them the authority and responsibility for promulgating rules, and they need to get those completed. And that I think there's a subtle message in that opinion to them as well.
You can tell we have quite a life. We're reading these opinions, trying to figure out what people are thinking about them. All right, so continuing with our legal developments, want to touch on this argument. I've seen it referred in some of the cases as a res judicata. It's not. Res judicata is where you have the same parties litigating the same issues to get a final ruling or judgment on that issue. And you wouldn't have the same parties generally here, and there's a notion of maybe mootness, and I think there's a standing argument mixed in here. But what it boils down to is you can't sue us to get relief that we're already under a court order to provide. So I'll give an example. Let's say, I use the example of going to another jurisdiction to sue me. So let's say we have a business. I have, Eric and Skip's Pizza, and we're delivering pizza all over the country, 24-hour service like Domino or like Amazon. And we get sued in Florida, and we immediately enter into some type of a stipulated settlement or order that says we'll make corrections to our website. And then we get sued a week later in Illinois because Skip is from Chicago, and the Chicago pizza, fights with the Florida pizza. So now there's a second lawsuit filed. Well, one of the arguments we might make in that second case is that there's a concept of res judicata, even though it might be a different plaintiff, it's the same issues, and maybe it's more mootness or that there's no standing because the plaintiff doesn't have a real injury here to be addressed, because what they're suing for, when you sue under the ADA, you're suing to get a remedy, and that is to bring the deficient access into compliance. So you're suing somebody and making them fix their website. Well, if we're already under a court order in Florida to fix our website, what's Illinois going to do? The order is just going to say the same thing. You got to fix your website like Florida says. And, in other words, you get a judge in Illinois saying, yeah, what he said down in Florida. And so it gives you an opportunity as a defendant to raise an argument that the issue is moot, or that the remedy the plaintiff seeks is moot because we're already in order to do the same thing.
And that's exactly what happened in Haynes versus Outback, because there was a prior lawsuit that was filed in district court in New York in 2016. And in that case, there was a judgment that was entered against Outback requiring it to comply with the ADA. So when Haynes filed a lawsuit against Outback in the Southern District of Florida, the district court judge said, we already have a judgment. Now, he recognized that the plaintiffs were different, but the defendant was the same. And because the judgment was corporate-wide to Outback for all its parent subsidiaries and related entities to come into compliance, he said, this is moot because there's no injury. They're already working on it.
And you'll see there, you see Haynes. This is another one of these situations with the, looks like a professional plaintiff. I don't know if it's the same person or not, but Haynes is suing all these businesses in the Southern District of Florida, and we're seeing, I think the trend is that the courts are not going to open those floodgates if they can avoid it. So if you're already under an order to make your website compliant, if you already have entered into a settlement agreement, perhaps that's enough. But there's also, it hasn't worked every time. So there's this New York case involving 5 guys. One issue there was the settlement agreement was confidential, but I got to think it was accessible by the court. Usually a confidential settlement agreement has a carve out that says we can share this with other courts and legal counsel and so forth. So I think there's probably more to that New York case on why that argument did not succeed, but it's definitely an argument you can make.
Well, a couple points. The Haynes in each of those 3 cases is the same plaintiff, and typically has the same plaintiff's lawyer looking for different defendants to sue. But the court in New York rejected the mootness argument, and it's interesting what the court said. It said that even though the defendant was in the process of updating accessibility of the website, it had not yet successfully done so. And until it's complete, being in the process was not good enough for that district court judge to say it was moot.
So, and that's going to go, in our recommendation, we say, start the process, put up the notice, but I don't think it's enough. I like this confident, or the accessibility banner, but I don't want anybody to get the wrong impression that you're going to put an accessibility banner up and you're good for the next 5 years. So I think, that's just a stopgap. So the ADA requires reasonable accommodation to provide access, and so the question becomes, well, what if I don't have a website that's compliant? I can't afford to make my website compliant today, and plus it's going to take time to do it. What else? Is there anything else I can do? And then here's some cases where the defendants had provided phone numbers. That's usually what they do. Is Skip mentioned this earlier, the accessibility notice, where you have a notice on your website and it says, if you're having trouble accessing any parts of this website, please call this number and we'll help you so that you can get same access to the goods and services. In that Dave and Buster's case, there was the defendant there cited a report from the DOJ, or some language from the DOJ, that discussed the possibility of covered entities, which is can be interpreted as depending on how the courts interpret that, if it's a physical location or whether somebody without a physical location is covered, but that you can essentially make reasonable accommodations by providing alternative access to the goods and services, and that's usually done through the phone number that's announced on this accessibility banner. But we put the 2 cases on here to distinguish one from the other. It's interesting. They're both, apparently, Mr. or Mrs. Robles here is a big pizza fan, and went to Domino's Pizza, and there's a nice accessibility banner there that tells people to call the number and order your food. And then you go to Pizza Hut, which is owned by Yum Brands, and there, we have the quote there from the court. Pizza Hut cannot simply post a customer service phone number on its website and claim that it is compliant with the ADA. So, the court there is telling us, look, you got to do more. You can't just put a phone number up there and think you're done. And we think that, I think that what you do is you start off with the phone number, with the banner, with the notice, and then make sure it's answered by a live person. Staff it as much as possible, at least during the hours that the business is open, and still work towards compliance. Some other issues to be aware of. I mentioned the issue with privacy policies earlier. There are, there's a growing trend, and Facebook was in the news recently because of, with the hearings and that group that provided Trump the information. So privacy is a big hot button issue already, And I haven't seen a privacy lawsuit, but I'm sure it's coming. So if anybody, if you're out there and you hear of one, I would love to hear about it. But I think what the argument would be is if you're required to have a privacy policy, even if you have one up, if it's not accessible, then it's kind of like, if a tree falls in the woods and nobody's around, or nobody hears it, what happens? Here you've got this situation. If you have a privacy policy, but somebody can't access it because of limitations based on their technology through which they're accessing the website, whether it's a screen reader or something else, then are you really providing a privacy policy? And I think that's going to be an issue. And the failure to provide privacy policies when you're collecting personal data can be consideration of violation of the FTC Act. So you need to be aware of that as well. For instance, with children, anytime you're collecting information with involving children under the age of 13, you could fall under the Children's Online Privacy Protection Act, which is a federal law, and you have to do certain things to be in compliance with that. So it's not only just website accessibility, but it's other issues where you have to make certain disclosures. One I just thought of here, and Skip and I have been involved in some litigation in the past involving this, is with affiliate marketing. If you go on and we may do a whole webinar on marketing and affiliate marketing, but if you go and you're selling services or goods on the internet through an affiliate marketing arrangement where you get a commission, the FTC requires you to make disclosures. But if you're not doing those in a manner that's accessible, can it be considered you're not making those disclosures?
Which brings us to the third-party vendor and website creator part of the agenda, and that is most people go ahead and hire somebody to create or update or monitor their websites. And the recommendation that we have is that you make sure that in your contract it states that the site will be in compliance with the laws, and that's the responsibility of the third-party vendor. So if it's not, and you do happen to get sued, you may have a breach of contract claim against the third-party vendor, or a claim for indemnification or contribution that you can use to your advantage.
That's right, and obviously that's something you need to be aware of as well. If you are in the business of doing work on websites, creating them or updating them, go back and look at your own contracts, see what you're promising people today, and see what you've promised in the past, and you may need to revisit that.
Eric, do you want to mention the advantage of working through counsel in doing some of those reviews?
Yeah, we have that on a slide. I think we'll get to it kind of when we make our recommendations, but certainly there's advantages specifically to working with counsel there because of confidentiality issues. I want to hit just finishing up some of the developments here. The other one I definitely want to address, even though it's not law yet, is this ADA Education Reform Act of 2017. It's HR 620, and the big piece of this, it's proposed legislation. It has not been adopted yet, and may not in fact be adopted, but it provides for a notice and cure period, which would really cut back on the lawsuits because you wouldn't get sued right away. And again, remember, these suits are oftentimes driven because the plaintiffs get attorney's fees from day one. So they're not going to provide you notice. They're just going to file the suit and let the attorney meter start to run, if the fee meter. And if this law goes through, it would require plaintiffs first to give notice that a business is not compliant with the ADA and let them try to make a correction before they file suit.
And if I remember correctly, Eric, I think the proposed legislation says that the attorney's fee clock doesn't start clicking until after the notice and cure period has expired.
That's right. And so it actually, if you have a business, it gives you a window to try and make the correction. Now, I've read a little bit on it, and I've seen some of the arguments for and against. And one of the things I think right away, which creates some ambiguity, is the language in the proposed law says that where there's an architectural barrier to access, you give notice and an opportunity to cure before filing suit. And the first question I would have is, is an architectural barrier to access, does that refer to a physical barrier, or can that be a virtual barrier on through a website? And I'm not sure that's entirely clear. And even if you go back and look at the initial language from the ADA, it's not entirely clear what the barrier refers to. And that goes back to one of the first legal issues we discussed today, Skip, was this physical access and the physical nexus. So I think they would at least need to address, define that better, because this law may go through. This was probably in response to all of these ADA suits involving physical locations. I'm not even sure that it doesn't specifically call out websites, so I'm not sure that it's in response to this issue. And the arguments for one of the arguments I've seen against this rule is that, well, now what you're doing is just encouraging businesses not to be compliant because they know they can sit back and wait until they get a notice, until that time, not do anything. And a lot of plaintiffs just simply won't complain, they'll go somewhere else. And of course, then the response is, well, if you don't do that and you provide the notice and cure, you at least give people an opportunity before they get whacked. And so is the threat of a lawsuit going to correct this, or is this going to be a good thing because it basically lets people have notice first?
My recollection, Eric, is that this law was originally proposed back in the Bush administration, when the administration was pro-business, and then it wasn't taken up, and then it wasn't really pursued in the Obama administration, and now with the Trump administration being more pro-business, somebody could make the argument it's come back up, and so from here it would go to the Senate, and then on to the president's desk.
And they have to address this website issue if they're going to push that through. It's somewhere in that law and definitions or in some comments. So, and this we've talked about previously, consequences for non-compliance. The big one here, you have potential money damages and, of course, attorney's fees. You have your own attorney to defend the action, and you could be responsible for the plaintiff's attorney's fees if you're a defendant gets sued. Also, if you are somebody with a disability and you're not able to access services or a website or a physical location, but in this case we're talking about websites, understand that you have the right to go get a lawyer and file suit to force that business or website to come into compliance. And most lawyers will take that on a contingent fee basis because they know that they can recover their fees from the business or the website operator under the statute. So now we talk about how do we come into compliance and what to do for checking compliance issues and if you're sued. And Skip mentioned earlier the issue of hiring counsel, and what we're recommending, sometimes we'll give you some stuff, we think you put the banner up, you put the phone number, do those things, but if you want to check out your website, we actually have a link on our website. Thank you, Tony Peasy, for having his group provide that link on there. It's a page off of our site. You can go on there, and it's a free service that we're providing for businesses to go on and check your website. It's not 100%. It's an automated process, but it'll give you a report. You'll have an idea of whether or not your website is has issues and errors. But there's no official guideline. I've heard people speak as though there is, but the one that's leading the charge, the one that the courts seem to be leaning towards is, well, at least if you follow this, is this the World Wide Web Consortium. It's W3C, kind of catchy, Web Content Accessibility Guidelines, and it's version 2.0, and they have an A, AA, and now AAA, so they keep updating this. And I'm not sure that, frankly, that covers everything. I know it covers the site reader, reader technology and some other issues, but there still may be issues beyond that. For instance, the flashing lights for epilepsy and so forth. Be aware that this could apply to your website or your mobile app. But when you go, if you're going to do a report, if you want us to do a report, contact Skip or I, and we can run a report on the website for you. But if you're going to hire somebody to do this, we are recommending that you do it through your attorney or through an attorney. And the reason why is that if the attorney goes out and hires an expert to review your report or review your website, then we have a good argument there that is attorney work product, and that our communication with you about that product is subject to attorney-client privilege, and then we won't have to turn that over. Whereas if you just go hire somebody, a company, to go do this for you, and they're not an attorney, they don't have the protection of those privileges of confidentiality, then you could be forced in a situation where you get sued and you have to turn that over to the other side, and you've just given the other side your roadmap or their roadmap to pick apart all the things that are wrong on your website, and to furthermore make the argument like they did in Winn-Dixie that, look, you have a report, you even knew things weren't correct, and you still haven't fixed them yet. So there's a big advantage in this particular instance to hiring an attorney for this. And then, you know, we talk about if you're going to have somebody do web work for you, make sure that they are working in compliance with these with the ADA requirements, and look for language in your contract, or have, you know, somebody review, have an attorney review your contract and make sure that you have language in there that requires compliance. Similarly, if you do get threatened with a lawsuit, or more likely you won't get threatened, you'll just get the lawsuit because of the fee issues, then if you pardon me, if you do get sued, you want your you want to look at your contract with your vendors if you had a vendor provide the service, because there may be an issue there. You know, your vendor, if they told you they were doing everything in compliance and they didn't, then that's something you may have a claim against your vendor. So we work with several different website providers and companies that provide those services, and we're encouraging you to go back now while you have the opportunity and look through these issues and figure out where you stand, and start taking corrective action before you get forced to do it by some aggressive plaintiff like out of South Florida, as we've seen. And then the banner and the notice, and we talked about that earlier. You know, these are the things to do, and Skip read the one example from that case. That was Domino's Pizza.
Mm-hmm.
And then we have a similar type notice on our website, so if you want to see an example, you can go on there and check. And if you have questions about that, again, you feel free to give us a call or shoot us an email, and we can try and help you and point you in the right direction. And then finally, you know, if you are sued, again, you want to get, you know, businesses can't represent themselves anyway, so normally a website is going to be owned by a business. And if you're sued, there's benefits to quickly jumping on it and getting counsel involved. And the main one is to figure out a way to stop the litigation from proceeding so that you're not you're paying attorney's fees for the other side. Because what the plaintiff's counsel will do, if they are filing these cases and they're driving for attorney's fees, what they're going to want to do is sue you, start doing some discovery, start doing a bunch of work on the case so they can keep the fee meter running. And before you know it, you're suddenly into like a good mid five-figure number. And instead, if you act quickly, get counsel involved, and Skip has handled these cases just on the physical barriers, and I've watched how he's handled them, the physical ADA cases. And why don't you tell Skip what you do, the steps involved?
I think the primary objective for the client is to figure out a resolution as quickly as possible, not only so you don't have to pay a lot of fees to the plaintiff, but also so you don't have to pay your lawyer fees. I mean, the quicker you get it resolved, the less money out of your pocket as possible. So I always try to be very proactive in first determining whether there's a violation, and then what's necessary to correct it, and try to get everything resolved and tied up as quickly as possible.
And another issue as well, as we mentioned earlier, is you might get sued a couple times. If you're a prominent business and you're doing business all over the country, either because you have a lot of customers and you're out in front of the public eye a lot, or just a stroke of bad luck, you could find yourself being sued here in Florida and being sued in another state. So the quicker you can come up with some type of, especially if you can get a settlement or a consent order where you're making corrections, it gives you a better argument to shut down litigation that might occur in other jurisdictions. Not only because you're fixing the problem, which gets rid of the risk, But if you're in the process of fixing it, as we mentioned earlier, you've got some arguments as well. There's other defenses that can be raised. There's been a couple cases where people say, well, the website's not compliant. Well, how have you been damaged by that? Well, if you haven't been damaged, if you're not trying to order pizza and you just don't like the fact that Pizza Hut's website wasn't accessible, you may have ways to kick out some of these lawsuits through some other technical means as well. And let's see, I think we've reached the end of our slides here. We kind of got through the material. Sorry for the initial we had an initial hiccup there, but if you have any other questions that you think of after the seminar that you didn't get a chance to ask while we've been going through the material, feel free to shoot an email to either Skip or myself. Our email addresses are down there, and you can go on our website. This is a work in progress. Let me point out, if you go to the ADA checker, I ran one for some clients the other day. It worked great. I don't know, maybe we're getting a lot of people looking at that. Skip and I have done. We spoke last month in this webinar. I spoke to a group this morning, and so we may have some other people that are running reports that may be a little backlogged. But if you have any issues, if you go there and for some reason you don't get the report, please shoot me an email and we'll make sure we get that to you. And with that, anything else that you would close out with, Mr. Skip?
I'd just say thank you for giving us the opportunity to speak with you this afternoon, and please don't hesitate to contact us if you have any questions or comments.
All right, and if you are an attorney and you need CLE credit, the reference number for this is Florida CLE credit is 1802952N as in Nancy. Again, it's 1802952N as in Nancy. And thank you for joining us again, and we hope you have a great rest of your day. Bye-bye.
Okay, Eric, great. Everybody's dropped off at this point. Can you guys go back to the beginning and take it from the beginning to like where you started? Because the recording, we're not going to be able to have the whole recording.
Start
from there, hello, and then go into like when you get into that third slide, just so we can patch them together.
That was so weird. I had the green on my microphone here, and then nothing was popping. I unplugged it, plugged it back in, and it worked. So,
we didn't get
and then also the website works. I think you didn't put the HTTP in, but in any case, I saw the one person that was on the webinar. They ran it for themselves, and it generated. So I'll forward you the report that they generated.
Okay, cool.
All right, take it from the top, guys. Welcome yourselves.
Well, good afternoon, and thank you for joining us today. My name's Eric Boughman. I am joined by my colleague, Skip Sell. Skip, you want to say hi?
Good afternoon.
And today we are talking about part 2 in our two-part webinar series on achieving website ADA compliance. Last month, if you were able to join us, we did sort of a broad overview of the growing tide of ADA litigation involving websites, some of the issues that businesses need to be aware of, and we did talk about some corrective measures, and we touched on some of the legal issues, but we didn't, we wanted to take today and do a deeper dive into some of those legal issues. So we wanted to provide solutions. We did some of that last month. We will do that again today. But today's really going to spend a lot of time focusing on the different court opinions around the country and some developing law that's going through the legislature right now. And hopefully you'll find some value in it. And we will, at the end of today's webinar, provide a CLE, a continuing legal education credit number for the Florida attorneys. Without further ado, we'll move into part 2 of achieving website accessibility. Here's our agenda of what we're going to talk about. Again, some brief background, and then we'll touch on web accessibility generally, what that means, what the issues are, and then we're going to dig into the legal developments. And there's been a lot of recent legal developments. In the last, within just the last year, we've seen a bunch of lawsuits here in Florida. We saw the first case go to a final judgment and happened to be here in Florida. We saw the Department of Justice, which had back in 2010 probably kicked off a lot of these issues, because in 2010 the Department of Justice had filed an advance notice of proposed rulemaking regarding a potential ruling on requirements for websites to be compliant with the ADA. And after 6-7 years of updates and machinations of what they were going to address and what they weren't going to address, then we have a turnover into a new, into the Trump administration, and on December 26th of 2017, the DOJ withdrew that proposed rulemaking notice. So it's now left this issue in the hands of the courts. And so we're going to dig into, in the recent legal developments, a lot of the court decisions. And then we'll again touch on, what the consequences are potentially if you're not in compliance. And then we'll give you some advice on how you can work towards achieving compliance and, hopefully avoiding a lawsuit. But if it happens, what steps you take if you are sued, how you can at least minimize or limit the damage and protect yourself. We'll welcome questions throughout the webinar, but we also have some time at the end to take questions. And if you have questions that don't get addressed within the next hour, please feel free to either email or call Skip or myself. Our email address and phone number are available in the slides that are also available here as handouts, or just go to our website, www.forsterbowman.com, and you can find Skip's smiling face there or mine, and give us a call or shoot us an email. So going first into just a little bit of background. We covered a lot of background last month in the webinar, so this is just kind of a broad refresher overview. And Skip, I've been talking for a little bit. You want to take that one?
Sure. Broadly, who's affected goes into 3 different groups. Of course, you start with the disabled individuals who are impacted, and then you have companies doing business on the web, and we'll get into some more detail later, but that's also broken down into those businesses that have a connection between the website and a physical location, and then other businesses that don't have a connection between a physical location and the website. Something like Netflix, for example, would fall into that category. And then the third group would be website developers and third-party vendors that either create the website, monitor the website, and deal with the website issues. And they're involved because they ought to be helping you make sure that your website is compliant with the ADA, particularly if you have a contractual relationship that puts that obligation on them. Why now is interesting. Part of the reason why we think it's an appropriate time to have this webinar with you is because of the continuing impact that the internet has on our everyday lives, whether it's personal or business or social. And almost everybody is on and impacted in some way by the internet. But the other factor there is why now is because of how quickly the lawsuits in this area have grown. If you look back at the stats for federal lawsuits in 2013 that involved the ADA, there was about 3,000 of them. In 4 years, by 2017, that amount had grown to almost 8,000. And Florida was third for the number of lawsuits. And website accessibility lawsuits have similarly grown. In 2017, there were 814 federal lawsuits on that topic in issue alone, and over 335 of those lawsuits were in Florida.
That's a lot of litigation involving this issue, and we don't expect that to shrink anytime soon. In fact, given the recent developments with a court decision coming out in this Winn-Dixie case here in Florida within the past several months, litigation continues to get filed. We just think this is going to be a growing issue, and businesses are going to be a target. Hopefully it works out well. Thanks for organizing there, and